Greetings, everybody. I'm Mark Gaston Pierce, Executive Director of the Workers' Rights Institute at Georgetown Law School. Welcome to part 2 of Labor and Employment Law under the Biden administration, the agency report. Those of you who attended yesterday's program witnessed a pretty dynamic discussion and very informative presentation by EEOC Chair Charlotte Burrows and DOL Director of Office of Contract Compliance, Jenny Yang. Today's presentation is sure to be as fitting, as exciting, as dynamic as you witnessed yesterday. You need to know a few things before we started. There are programs, there are materials that are available for downloading, found in the handout section of the dashboard on your screen. If you're on a tablet, this may be found on the menu bar at the top of your screen next to the question mark icon. Click on what looks like a piece of paper with the on the lower left-hand corner turned down. In addition to the handout section, you'll find a CLE form. Thank you, Sapart Shore, for sponsoring the CLE credits today. If you're interested in CLE credits, you will need to download this form complete and return it to Sapart using the email address that is found at the bottom of the form. That's cle@sapart.com. You can also mail Susan Wan. I will provide the CLE code that needs to be included about 5 minutes before the end of the program. And I can't do it any earlier because you need to see our charming faces for the duration, and then you'll get the code. All right, wonderful. Now let's get started with some biographies, and I apologize in advance because my illustrious panel has so many accomplishments that if I were to read everything that they have accomplished, we would not hear from them. But I'll start out with Patricia Smith. She's currently Senior Counsel to the U.S. Secretary of Labor, Marty Walsh. Former Solicitor Smith, who prefers Tricia, was most recently counsel for the National Employment Law Project, where she was central in developing and implementing a wide range of advocacy strategies to fight attacks on workers and to continue to advance a pro-worker agenda at the federal level and at the states. From March 2010 to January 2017, Tricia was the Solicitor of Labor at the U.S. Department of Labor. As Solicitor, she served as Chief Legal Advisor to 2 Secretaries of Labor and directed a staff of over 650 across the country. She played a key role in the Labor Department's signature achievements under Barack Obama, including rules advancing overtime protections, regulations protecting workers from deadly silica and coal dust, and a rule designed to prevent financial advisors from mishandling workers' retirement funds. Tricia also worked with the DOL enforcement agencies in developing and implementing major enforcement initiatives, including the Wage and Hour Division's Misclassification Initiative and OSHA's Temporary Worker Initiative. A graduate of Trinity College and NYU Law School, she is a fellow of the college, and she previously served as New York State Commissioner of Labor, where she led the enforcement of labor laws throughout the state. And despite her rigorous enforcement schedule, she took time to give me a call and talk to me about serving the state and got me on the Industrial Board of Appeals. And yes, I forgive her. No, I love the fact that she did that, and we've been friends ever since. Now, Welcome, Tricia. Acting NLRB General Counsel Peter Orr. Peter is also a good friend of mine. Born in Seoul, Korea, he received his bachelor's degree from University of California, Riverside, his JD from Pepperdine Law School, and an MBA from Hawaii Pacific University. He began his illustrious career at the Honolulu resident office of the NLRB, moved through the ranks of the NLRB, and ultimately became regional director of the storied Region 13 Chicago office. As regional director, he was responsible for presenting many important issues to the board, including the Northwestern University decision, where he initially found, as regional director, that the scholarship football players' students were in fact employees. And as you know, the board punted on that. We decided not to take jurisdiction over that, but we have not passed, well, the board has not passed on the merits of that determination when it declined that jurisdiction. Immediately after taking office, President Joe Biden dismissed General Counsel Peter Robb, and within days thereafter named Peter Orr acting General Counsel to the NLRB, a position which he currently is serving. And we'd like to welcome him, and I can't wait to ask him about, what do you mean by I won't be a potted plant? Now, Judy Conte, another friend of mine, is a government affairs director for the National Employment Law Project, having joined NELP in 2007 after spending 7 years as the co-director and executive director of the DC Employment Justice Center. For many years, Judy has been involved in lobbying on issues affecting low-wage workers, including raising minimum wage, fair chance hiring, unemployment insurance, wage staff, immigration reform, and other issues. In her time with NELP, she has made significant achievements in developing the organization's presence on the Capitol, where she's committed to bringing the expertise and experience of NELP staff and allies to the halls of Congress and relevant cabinet and executive agencies. A graduate of Williams College and William and Mary Law School, Judy has been widely recognized for her work with awards from the American Bar Association, the Washington Area Women's Foundation, the Hispanic Bar Association of DC, and DC Jobs with Justice, and of course her alma mater, William and Mary Law School. In addition to her advocacy, Judy is widely respected as a media resource. She has appeared on C-SPAN, Washington Journal, CNBC, MSNBC, Fox Business News, CBS News, and the BBC. Yes, they listen to her in England too. We are lucky to have her, and she will be commenting on a lot of what is going to be said by our agency officials today. Greetings, Judy. Larry Lorber is a labor and employment counsel for Safeguard Shore, where, among other abilities, he translates government action into practical, productive advice for his clients. Larry, I've always had a hard time doing that with my clients. He represents many clients before the Office of Federal Contract Compliance Programs, the Wage and Hour Division of the Department of Labor, and the EEOC. A fellow of the College of Labor and Employment Lawyers, Larry is a graduate of Brooklyn College, yay Brooklyn, University of Maryland, Francis King Carey School of Law, and among his many positions of federal public service, Larry previously served as Deputy Assistant Secretary to the Department of Labor, Executive Assistant to the Solicitor of Labor, and Director of the DOL's Office of Federal Contract Compliance Programs. Larry has chaired the U.S. Chamber of Commerce Equal Employment Opportunities Subcommittee for more than a decade and served as a management co-chair of the American Bar Association's Subcommittee on Federal Legislative Affairs. Thank you so much, Larry, for joining us, and greetings. Okay, well, I think we are going to just get really started because we have a very ambitious agenda, and I don't talk that fast. Okay, first of all, Tricia, what is your current responsibilities as Senior Advisor to the Secretary of Labor?
I do whatever he asks me to do.
Will you also be assisting the solicitor once Seema Nanda is confirmed?
No, I'm a big advocate that the solicitor's office is the legal counsel, and I'm no longer in the solicitor's office. So we will hopefully very soon have a confirmed solicitor, and I will be doing anything that secretary asked me to do, but give legal advice.
Okay, wonderful. Now, let's talk about the independent contractor rule. In one of its first acts of the year and one of the last acts of the Trump administration, the Department of Labor on January 6th issued its final regulation for the classification of independent contractors, the independent contractor status under the Fair Labor Standards Act. This is where a new standard using an economic realities test that made it easier for employers to classify workers as independent contractors under the FLSA. It was supposed to take effect March of this year, but was delayed until May. Following the announcement of the postponement, the effective start date, the Biden administration proposed that it would be completely rescinded and instead revert back to a more employee-centric standard from the Obama administration. What is the current state of the independent contractor rule under the Fair Labor Standards Act?
Well, the Trump administration rule, as you said, was rescinded on May the 6th. And along with that, were rescinded a few opinion letters that were basically based on the interpretation of the FSLA that the Trump rule purported to have. Right now, what the Wage Hour Division has put up is fact sheet 13, which, by the way, is a fact sheet interpreting employment under the FSLA that was originally put up during the Bush administration. So it has not reverted back yet to anything in the Obama administration. It actually is using the long-standing interpretation of at least 60 years of the economic realities test. There isn't a confirmed, as you know, there isn't a confirmed wage hour administrator. So what will happen going forward with those interpretations is yet to be seen. But keep in mind that what fact sheet 13 does is interpret what the courts have said about the economic realities test. And what the Obama era administrator's interpretation was basically doing the same thing, but updating it because there had been further cases. So we'll just have to see what will happen with that going forward.
Okay, and fact sheet 13 is in your materials that you can download. Now, has the DOL issued new guidance or begun any new? Oh, well, you answered that. There's
I mean, there's one thing I think that we need to talk about when we talk about the independent contractor rule, and if we talk about the joint employment rule, which is that they are interpretive rules. Congress has not given the Department of Labor legislative rulemaking authority to determine who is an employee and not. So what the department has done, and it has done always, is follow Supreme Court precedent. Now, it's true in the Trump administration, they did their rules through notice and comment, in large part because the Trump administration had an executive order saying significant guidance had to go through notice and comment. An executive order which was revoked by the Biden administration. So what will happen, how the department will go forward in its interpretations, it has the choices of, it could go through notice and comment rulemaking, but it would still be an interpretive rule. It could issue an administrator's interpretation. It could issue opinion letters. So we'll just have to see what this administration will do going forward for that.
Okay. Judy, do you have any thoughts on that?
You know, at NLRB, we are certainly heartened to see that the Trump era guidance on independent contractors was withdrawn. We think it was absolutely contrary to law. It went beyond the scope of what the FLSA allows, and it went beyond the scope of very clear precedent from the Supreme Court and the circuit courts as well. We are very confident that had it been finalized, it would have been struck by the courts, just like the joint employment interpretive reg was as well, for going beyond the scope of the law. So we're heartened about that. You know, at NLRB, we are very concerned about what David Weil, the former administrator of the Wage and Hour Division, talked about, the fissured workplace, with, you know, the ever pressing desires of employers to obscure the employment relationship between two entities, you know, making it harder to ascertain whether somebody is employed by entity A or B, subcontracting, calling people independent contractors when they really aren't. We know there are scores of genuine independent contractors out there, people who are legitimately running their own businesses and self-employed and want that flexibility and want that autonomy, and that's great. But there are many people upon whom the term independent contractor is involuntarily foisted. And when that happens, they lose out not just on wage and hour protections, but workers' compensation, unemployment insurance, the protections of the Family Medical Leave Act, our civil rights laws. And it is a trend that continues to degrade the wages and the benefits that people receive, and is a trend that is part of the calculus of the growing economic inequality in this country. So we look forward to working with the Department of Labor, but also look forward to working with allies across the country to make sure that when workers are misclassified as independent contractors, they get reclassified appropriately, and to make sure that the laws at the federal government and in state governments as well aren't rigged against workers who just want economic security and just want to know who their employer is, who is responsible for good wages, good benefits, and safe working conditions.
Okay, Larry?
Well, let me sort of just respond generally. First of all, what the Trump folks did on January 6th really, in one respect, was a continuation of what former Administrator Weil did.
Larry, your sound is wobbling a little bit.
Okay. They interpreted current court decisions. We really shouldn't go back 60 years because the workplace obviously has changed. Growth of independent contractors or gig workers, or whatever you want to call them, has been substantial and certainly over the last 10 years.
We're being deprived of your wisdom because of the audio a little bit. So I'm going to move to another question, and maybe you can tweak your audio a little bit, and then we can get back to you.
Okay.
The Trump administration issued a final rule that interpreted joint employer status under the FSLA. This rule narrowed the definition of joint employer by adopting a 4-factor balancing test to assess whether a business could be jointly liable for any FSLA violation. 18 states challenged the final rule in court, and on September 8th of last year, the District Court of the Southern District of New York subsequently struck down a major portion of the rule, essentially nullifying its effect. Tricia, what was the problem with the final rule?
Well, again, it narrowed the definition of joint employer, and it did so by basically assuming, if you read the rule, it assumed that there was an employer and that you were just trying to get a second employer, and that was the joint employer. And so it used a very narrow definition of the statute. The problem is that's not how the statute works. I mean, what joint employment recognizes is that people can have two employers, and there's not a situation where there's number one and number two. In many cases that I've seen, both putative employers say they're not the employer, so that you don't have like the one employer acknowledged in the second. And so it narrowly interpreted it by basically saying for joint employment, you don't use suffer or permit. You don't use the economic realities test. And that's basically what the court held when it struck it down. It said that it was contrary to the law.
Oh, okay. What is the current state of the joint employer rule under the FSLA? Is there a functional rule now that employers and workers should be guided by?
Well, as you mentioned, the district court vacated the rule, and the Trump administration did not ask for a stay of that vacation. So technically, the rule is vacated. And I don't think, but it's vacated, but it has not yet been rescinded. So the Labor Department put out, proposed to rescind the rule in March, and again, through notice and comment. The comment period has closed, and so I think we will see a final decision on rescission or not coming out soon, but we haven't seen that yet. The other thing that happened is that the Trump administration, in the last days of the administration, did file a brief, and the second appealed and filed a brief defending the rule. The Department of Labor asked the Second Circuit to postpone briefing on that appeal pending their decision about whether they would rescind the rule or not. The Second Circuit denied that motion, and the Department of Labor has a brief that's due in the Second Circuit now on May the 28th. And they are in discussions with the Solicitor General's office on what exactly that brief will say.
Okay, all right. That sounds definitive. Larry, are you able to comment on that, or you're still?
Yeah, hopefully this sounds better.
Okay, yeah.
Just a couple of things. First of all, one thing should be noted that the Supreme Court has not looked very kindly on the ping pong change in government policy with a change in administration. It said that during the Bush administration, when it changed policies, and what's happening now is more of the same. In terms of the joint employer, the Second Circuit has not apparently looked kindly on the Labor Department's asking for a pause while it considers what it does. So that I think you're going to have to look to see what the courts finally do, and I would assume some of this will get to the Supreme Court. And indeed, on the independent contractor, there's litigation now about the stays. I don't know that that will be successful, but obviously, you could anticipate litigation there. I think it's unfortunate in both instances, very briefly, because there has been a change in the economy. There's been a change in employment relationships and business relationships, which is what the joint employer rule pertains. And going back to a period of time when things were a lot more static and unchanging doesn't really reflect, I'll use the term, the economic reality of what's going on now. Administrator Weil back issued his AI talking about his view of court decisions. That changed the prior interpretation. So updating interpretation seems to be something that's appropriate for government, except apparently when the updating doesn't meet other people's views of what the government should do. So, in summation, I would imagine whatever the Labor Department does, you're facing significant litigation potential. The Second Circuit has to rule on the Trump joint employer changes. I would imagine there'll be additional litigation if we go forward with either reverting to old independent contractor and joint employer determinations, or indeed trying to fashion new ones. Though what I hear from Trish and Judy seems to be they want to sort of go back to the future rather than advance the process a bit.
Tricia, you wanted to comment on that?
Yeah, I mean, I agree that updating interpretations of what the courts have said is totally appropriate. But the problem with the Trump rules is that they just didn't update interpretations of what the courts have said. They basically, in some ways, ignored whole parts of the statute. And you can't ignore the statute until Congress changes the statute. So, and that's a difference between rewriting the statute and updating court interpretations.
Mm-hmm. Judy?
You know, we hear often about how much work has changed and how different things are, but I think it's important to look at what's driven how much work changes. Yes, technology is certainly part of it, but you know, people love to talk about the gig economy, for example, and how revolutionary and life-changing it is. I mean, people picking you up and driving you to places are taxi cab drivers who have been driving since, you know, modern times immemorial. Delivering food, you know, pizza parlors have been doing that across the country for decades upon decades. Yes, there's new devices that allow more people to engage in that, but the nature of work actually hasn't changed all that much. What has changed more, I think, is the ways that employers are trying to characterize, or in some cases mischaracterize, what work is. What hasn't changed is that people work not just for the rewards of a good career, but because they need income to support themselves and their families. They need good benefits in order to make sure that they have health care and resources in times of emergency. And that the economic security that workers need hasn't changed a lick. What is happening is more and more workers aren't getting the economic security they need, unfortunately. But you know, I'm a little skeptical of all of these notions of work changing so dramatically. I really think it's the ways that people try to characterize work that has changed dramatically. The basic need for people, for adults who have to support themselves and their families, to have good jobs with reasonable hours, safe working conditions, and the kind of benefits and wraparound supports they need to support their whole life. Really, that hasn't changed, but for the fact that there are now more women in the workforce, so there are more, you know, family supports and benefits that are needed. But you know, the nature of work, I think, remains very much the same. What is different is the added flexibility that people can have, the added ways that people can be engaged. But that doesn't necessarily call for wholesale abandonment of basic wage and hour and civil rights protections.
Larry, you wanted to weigh in on that?
Yeah, very briefly. The current, I guess, chief labor advisor to the president is Seth Harris. He was formerly deputy secretary when Trish was at the Labor Department. Wrote a very extensive piece really addressing the change in the workplace. And he talked about creating a third standard, if you will, between employees and independent contractors, and parenthetically, I suppose, touching on the joint employer situation. And he recognized the fact that there have been changes. The other point I would simply make is that while we're talking about the FLSA and its requirements, much of what Judy talked about and Trish involved other statutory protections emanating from those statutes, the FMLA and those. And therefore, I find it strange to try to use the FLSA to change the structure and import of those other independent statutes. So if we're talking about a need for statutory cohesion, then follow the statutes. And if you have to change the coverage of those statutes, then I suppose you amend the statutes. This is not to say there can't be changes. Again, the Seth Harris proposal I thought was fascinating. Not that many employer groups, I don't know, have adopted it, but he, Senator Warner, others have talked about a third level of not employment, but economic relationships, where you can have some of that. So that's just the only point I'd make.
In Ontario, in Canada, they have something similar to that, a dependent contractor status, where the dependent contractors can unionize, but still keep certain aspects of independent contractor criteria. It's fascinating.
One last comment, which is the Seth Harris proposal was a legislative proposal. Seth recognized that to do that, you did have to change the statute, and we've been talking about interpreting the statute as it's now written.
Okay. I'd like to move on to the Trump era tipped worker rule. Now, the DOL announced that part of that Trump era tip worker rule that deals with monetary penalties and workers who perform tipped and non-tipped duties was to take effect March of this year. Tricia, why was that rule delayed until April of this year?
So that's a complicated rule. I mean, in part, the Labor Department was engaging in that rulemaking because there had been a legislative change, and that the Congress determined that if an employer didn't take a tip credit, that the tip pool could include back of the house workers, which had not been the case previous to that. But in the course of engaging in that particular rulemaking, and Congress also said that the managers and employers could not keep any part of the tips. So as in part, they were engaging in that rulemaking. In part, they went beyond that sort of congressionally mandated rulemaking. Not that they were precluded legally from doing it. I'm not trying to say that, but there were other issues that went in there. One was what we call the dual jobs rule, that how do you treat a situation where a worker is working in both a tipped occupation and a non-tipped occupation, and even going further, what do you do when you're working in a tipped occupation, but not all of that work is tip producing work? Can you still take a tip credit? So those were parts of the rules that related to tips. There were other parts of the rule that basically related to the definition of willful that went way beyond the tip area. So what the department did, they did a first delay to determine which parts of the rule they wanted to reconsider and which parts of the rule would go forward. And so what has happened is that part of the rule has gone forward, and part of the rule has been further delayed. And I'm assuming that it was delayed until December, and you can just imagine that's because if the department does want to engage in further rulemaking, it wants to be able to complete that rulemaking.
Mm-hmm. So the provision concerning issues such as tip pooling and record keeping, that went into effect, is that right?
Right. The other thing that went into effect was their definition of managers and supervisors, although that's not to say that if there is further rulemaking, there might not be further changes or at least questions on whether or not those definitions which have actually gone into effect would stay in effect.
Now, one provision that jumped out when I was trying to understand this was that the provision did away with the so-called 80-20 standard, under which the employer can only pay the sub-minimum tipped wage if less than 20% of the employee's work is untipped. The 80-20 standard had been a longstanding DOL policy before the Trump administration sought to axe it. What was the reasoning behind that? If I understand it correctly, it's gone, right? That 80-20 standard.
The 80-20 standard is gone right now. The rule which the Trump administration wanted to substitute, which is that so long as it's continuous and reasonable, you can take the tip credit even if the worker's not engaging in tip producing work, has been delayed. And as I said, it's been delayed until December, and so I think people can anticipate that the department is contemplating new rulemaking.
Okay. Judy?
You know, we were of two minds of this regulation. The part about tip pooling, you know, we had some suggestions of further clarity we wanted from the Trump administration, but you know, that was a provision that was negotiated between Democrats in Congress, the Trump Department of Labor, with folks like NLRB and the National Restaurant Association advising in the background, and it was a great bipartisan victory, the rare one that we see these days, where we agreed that under the right circumstances, broader tip pooling was a good thing, both for businesses and for workers. The part we objected to strenuously, of course, was the abrogation of the 80-20 rule. And here's why, you know, reasonable is in the eye of the beholder. And when you tell a bunch of employers that they can have somebody do non-tip generating work for a reasonable amount of time, I mean, I've been a tipped worker myself. Back in high school and college, I worked at restaurants at the Jersey Shore for 8 summers. And I will tell you, I had some wonderful employers. I had some awful employers, and the awful ones tried to take advantage of people at every chance they could get. And you know, the people they were taking advantage of were largely high school and college students or women who were working these low-wage jobs full time. And none of us felt terribly empowered to protest anything that we thought was wrong or unfair. So there were times, even with an 80-20 rule and even with guarantees of protections that I had, where I know in retrospect my rights were absolutely abused, and I didn't know. And if the rules are further relaxed, imagine how much worse they could get. So I don't say this to suggest that, you know, every tipped employer is going to work every angle to take advantage, but there are plenty that will, unfortunately. And again, even among people of goodwill, again, reasonable is a very squishy standard, if you will. You know, we hear from the management side bar appropriately that employers are looking for bright lines. They're looking for rules that they can follow so they don't set themselves up for litigation problems. And when you have a test that says somebody can do non-tip generating work for a reasonable amount of time, I think you're just setting up everybody on both sides of the equation for a lot of trouble. So we look forward to seeing what the Department of Labor will propose in a new rulemaking, and hope that it can lead to a fair and well delineated solution for both workers and business alike.
Larry?
Oh, very briefly, I think Judy appropriately talked about the really the meeting together of the labor and employment and employers to come up with the tip pooling rule, prohibiting employers or managers from taking the tips was a necessary step which Congress enhanced. The only point I'd make is that increasing the number of people who could participate in tip-based compensation is not unhelpful. You can look at what happened in the District of Columbia, which had to rescind its proposal because of opposition from tipped employees, restaurant employees, that they would lose the benefit of tips. And it's just finally, just to note that the tip rule never allowed employees to work for less than the minimum wage. Tip employee rule required that employees get the minimum wage. If the tips did not, at the percentage allocated, did not reach the minimum wage, that would have to be, their compensation would have to be increased to reach that. So I think this is an area clearly where there are a lot of grounds for cooperative review if the Labor Department wants to clarify the rule further. I know employers in that world would love to have a standard that they could follow and live by.
Okay. So at present, the 80-20 rule is not in effect. There will, I got a question as to what the text of that rule would be. I would imagine that it would still be on the DOL website, but indicated that it's not in effect. Because I did not include the 80-20 rule in our materials, and I apologize for that. But I'd like to talk about paid leave if we could. The pandemic has exposed the need for paid leave for families after COVID-19, and that crisis, and it will be something that will be needed until that crisis completely subsides. States such as California, New York, New Jersey, and Rhode Island have adopted paid leave programs that provide medical leave to attend to serious health conditions of family members. In February, Senator Kristen Gillibrand and U.S. Representative Rosa DeLorio reintroduced the Family and Medical Leave Insurance Act to create a permanent national paid leave and medical leave program that would apply to all employers, regardless of size, and would include self-employed or part-time employees. Is this legislation needed, Larry?
Yes, I think this is one area where I can tell you that there have been several employer groups. One group, the Chamber of Commerce is deeply involved with, to try to come up with a rational paid leave plan for employers having 50 states plus lots of municipal jurisdictions coming up with their own paid leave rules, either paid leave or paid sick leave, and there is a difference between the two, is a very difficult situation for multi-jurisdiction employers. It's extremely difficult to follow and comply with. So I think for employers coming up with a standard that reflects what they think they could live with, whatever that is, and I'm not part of that, but having to have a paid leave standard would be something that would really be welcome. I would add one point, which I think my colleagues may not like, that one of the problems with labor law is that there really is no preemption other than the NLRA. There really is no preemption, so that what you have are not the top of requirements, but sort of the base requirements, and other jurisdictions can go above them. I leave to others to determine that on the macro level, but in the paid leave level, it seems that some degree of uniformity would be helpful as long as there is paid leave. As I said, there's either paid family leave, paid sick leave. There are lots of intricacies which have to be worked out. But if the question is, should there be a national paid leave law, I would think most employers would say yes if it were national. And I'm not going to get into the issue, Judy, of what's defining reasonable paid leave, but conceptually, I don't think there's an objection to it. As I said, the objection is the multiplicity of requirements under state and local laws, whether it's sick leave or family leave. As you know, DC, for example, has both a Family Medical Leave Act and a Family Parental Leave Act, and they have to be read separately. So it's a very difficult situation, and coherence would be very helpful.
Judy?
Yeah, Larry and I are very much in agreement on most of the things here. And indeed, the consensus for paid leave is one that has grown in recent years, even before the pandemic. You know, we know that people need some measure of sensible paid leave in order to take care of their own medical needs, the needs of their family and dependents as well. And I think Larry's right about the 50-state patchwork in the sense, and that it is the administrative difficulties of taking care of all of the different programs are legitimate. It's not hard to say in this state somebody gets 12 weeks, in that state somebody gets 16 weeks, but the different mechanisms do become difficult. I certainly know, like, NLRB has offices in Washington State, in California, in New York, in DC, and then we have other people working out of their homes in a few additional states like Connecticut. And over the past year, as our admin folks have been dealing with the Families First Coronavirus Act, I mean, we had paid leave already, of course, but making sure that we are compliant with all the different responsibilities of, in a small organization of 45 people dealing with at least 4 jurisdictions has been difficult for them. And I hear that as well from other folks in other nonprofit organizations that span multiple states. So I think I've heard people from the employer community suggest that in the paid leave context, for example, that there doesn't necessarily need to be preemption in the sense that states can't go higher, but what would be great is if there were one uniform system that administers all federal or state paid leave programs across the country. And if that mechanism basically was centralized, if that sort of preempted other mechanisms, that would be very useful. And then from there, complying with different amounts of paid leave, for example, or perhaps slightly different versions of who is eligible for it wouldn't be so burdensome. So I think that's one of the areas where there's room for discussion, and it would be good if representatives from, advocates for workers as well as for business could come together and work on those practicalities.
Now, the Biden administration supports a program that provides 12 weeks of paid family and medical leave for all workers and up to 7 days of sick, family, and safe leave. I would speculate that the chances of passage is anybody's guess. But Tricia, as we need to move on, I'm curious, does the president or the DOL have the ability to do anything while legislative reform is under consideration?
Well, they have some authority. I mean, in the Obama administration, the president issued an executive order that would require federal contractors to provide a certain amount of paid leave. The Trump administration did not revoke that order, and it remains in effect. The other thing that the DOL is trying to do, in the original CARES Act, there was mandatory paid leave for certain conditions related to the COVID crisis. And when Congress went to re-up it, it did not re-up the mandatory leave, but it continued tax credits. I mean, there were, at the same time, there are employers who do provide leave for the various reasons related to COVID can get tax credits and pay for it. And one of the things that the department has been doing is, as it goes around and it's one of its COVID related, I think we're going to talk about that, essential worker programs, it reminds employers that if they do give these types of leave, they can get tax credits.
Okay, well, that gets us to the essential workers program, and then we're going to have to jump to the NLRB because there's a lot that we would want to cover there. The essential workers protection initiative is an interesting development. On April 26th of this year, the Department of Labor announced an initiative to help workers deemed essential during the pandemic better understand their wage and hour rights. Tricia, what is the purpose and function of this initiative?
Well, during the pandemic, we've been, hearing a lot about the importance of essential workers, whether they be grocery store workers or nurses or healthcare workers or delivery people. But we've also at the wage hour division, they've also noticed an increase in complaints from those essential workers. So the point of this initiative is to sort of reach out to these folks who, you know, in the vernacular we call heroes, and make sure that they understand what their rights are so that they can enforce those rights.
Mhm.
Again, we're talking rights that the Wage Hour Administration would enforce: minimum wage, leave rights, overtime rights, those type of things.
Okay. All right. Well, what I'd like to do is talk a little bit to Peter about some NLRB topics, leaving on the table a lot of other questions related to DOL, but that's what happens when we have this hefty, ambitious agenda. Now, Peter, while you can't weigh in on the propriety of the appointment of Jennifer Abruzzo, I understand that she is out of committee with an 11-11 tie, and where we have to see what will transpire for her confirmation. But in the meantime, you have been serving as acting general counsel, and not without controversy, because you know there are folks that are a little annoyed at the prospect, at the fact that Peter Robb was dismissed and you replaced him. I'll relate some of the arguments associated with that. This is unprecedented, and the then sitting president, with the advice and consent of the Senate, appointed the general counsel for a term of 4 years, and those 4 years had not expired. Even President Harry S. Truman replaced the NLRB general counsel, but only after he requested that he be removed, and he voluntarily left. Now, on the other hand, the act provides no limitations on the president's authority to remove the general counsel, stating only that there shall be a general counsel of the board who shall be appointed by the president by and with the advice and consent of the Senate for a term of 4 years. The president, another argument is that the president does not have the authority to remove an officer with adjudicatory authority. The response to that argument I've seen is the general counsel authority is executive in nature. It's not adjudicatory. The Supreme Court has long held that a statutorily fixed term of office is a limitation on the office holder's length of service, not a limit on the president's authority to remove the officer during the term. And in the absence of specific provisions to the contrary, the power of removal from the office is incumbent to the power of the appointment. Both Eisenhower and Reagan administrations concluded it had the authority to remove the NLRB general counsel, but just did not act on it. In fact, Chief Justice John Roberts, when he was then a lowly White House counsel, recommended and penned a memo to President Reagan that, yes, you can remove the general counsel of the NLRB, but it didn't happen. Okay, so Peter, with that set up, after the board's experience with the Supreme Court in NLRB versus Southwest General, which involves challenges to the authority of the then acting general counsel, Leif Solomon, and held that a nominee can't be acting general counsel, and as a result, certain of his actions were invalidated. Would you say that a confirmed general counsel has the authority to ratify the actions of an acting general counsel? How's that for a leading question?
Well, first, it's wonderful to be on screen with you, Mark, and everybody else. Although Larry needs to be on the phone for some reason. So, you know, the past experience would tell us that a ratification of a previous acting general counsel would be sufficient. Courts have found those ratifications sufficient, as long as the ratification indeed was genuine, an opportunity for the Senate confirmed general counsel to have an opportunity to review the decision-making documents and to reach a decision independent. And if done so, then the ratification would be sufficient. But the issue still, I think, is going to remain with regards to the challenges to Peter Robb's removal through the period that the argument is where he should have been still the general counsel through the end of November. And all the arguments that you point out, all the arguments on both sides that you pointed out, clearly find in the many briefs that have been filed on both sides. Agency has argued in briefs to the board, similar arguments that you laid forward, as have parties challenging the removal. Where we are now, however, is, if you folks probably know, in the board decision in NABED, where the issues were presented for the board members to determine whether the removal and my designation was appropriate. The board, unlike other boards, declined to make a ruling on that, and instead stated that it was exercising not to take up the jurisdiction issue, but nevertheless, because of the operational need for the agency to move forward, they were making a ruling on the merits of the case and allowing the federal courts, whether circuit or district, the federal courts to rule on the issue about the removal and the designation. So those issues are still going to be outstanding, and as it is now, based on the board's position, going to be decided by the court. And right now we have two specific court cases in federal court. One on an enforcement matter in the Fifth Circuit, one in the district court in the Western District of Michigan matter that have these issues presented to the courts. They're very early on, so there hasn't been any briefs submitted yet. So it looks like, at least for now, that these two courts have the opportunity to weigh in on these issues. There will be many other filings that I'm sure will be coming that will, and depending on how quickly the courts get to it, those may be the first to address the issue. But the board is not going to address the issue, which leads me to the final comment about, going back to the question about ratifying. One could predict that the issues about removal and even a Senate confirmed general counsel would be challenged all the way through until November. So, occasion of a acting or even a permanent general counsel could still be challenged, which would then require a ratification, which I think would work.
I see. Larry, you got any view on this?
Not really. I think Peter seems to be doing a great job. I just have to say that this whole business of people with term appointments being removed is just a difficult question, regardless of who's being removed and who's the remover. I think that Congress intended 4-year terms, and as you know, they did it also to the general counsel of the EEOC. If Congress intended 4-year terms, it stated it. It raises all sorts of questions about the unitary president and all of that, and that's beyond, obviously, our scope. But again, you know, for employers, they would like decisions that they would like, but they would also like consistency, and that's quite important as well. So.
Yeah. Judy?
Yeah, I don't have any insight to add to Peter's. He covered it so thoroughly. I will say though, you know, and again, this is teeing up a discussion that's beyond this as well, but I do think that there are broader, interesting questions too about just how many confirmable jobs we have in this government, right? Not just in the labor and employment context. But it takes a long time to get the thousands of people that need to be confirmed. And certainly we want cabinet level secretaries and deputy secretaries and people like the general counsel of the NLRB and members of adjudicatory boards. But I think there's a really big and interesting question to dissect some other day about whether we've got way too many potential confirmees and whether that that hinders an administration from achieving its goals.
Okay, well said.
I think Judy makes a terrific point, and I think, you know, when you read the NABET decision, board's decision, they are essentially saying, while the legal challenges are real, there is an NLRA and an NLRB that's supposed to enforce it, and everything can't come to a standstill. So even the board has to make a decision on the merits of the case, right? Acting, challenges, removal, all of that, and the real issue being we have laws that need to be enforced.
Yeah. Well, Peter, you're NLRB born and bred, having started as a field attorney in the Honolulu office, as your bio indicates. You moved right up through the ranks. And when you were asked after being named acting general counsel what your intentions would be in the interim capacity, you stated you didn't intend to be a potted plant. What did you mean by that? I don't see any plants behind you in that office, by the way.
It was simply, I just alluded to Judy's comment. There's a National Labor Relations Act that's in existence. There are workers who are looking to the agency for protections at the workplace. The agency has to effectuate the act, and the decisions have to be made in order for that to be done. And by being asked to be the acting general counsel, being mindful of, I'm not the permanent general counsel, but when decisions have to be made, when the agency has to move forward, those decisions must be made and must be affirmatively made versus reacting. You don't, you know, as an enforcement agency where we don't have the power to sua sponte charges or allegations, when people are coming to the agency because often in their most difficult times of their lives, it's incumbent on us to be proactive and work on those matters based on mission of the National Labor Relations Act. And that's all that I meant. I have no certain illusions that I'm going to make permanent changes, but I do have a belief in what the agency should do and what the act should stand for. And to the extent that I have the opportunity to do that, that's what I will do.
Okay, well, part of that was, well, you rolled back at least 10, maybe more, of the policy memos that was issued by your predecessor. Could you discuss the reasoning for rolling all those policies back? This was, I believe, in your memorandum GC 21-02. Can you talk about that a little bit?
So, I think for me, having been with the agency for as long as I have been, and having worked in headquarters, and as you know, I was chairing the regional director committee, a group of regional directors throughout the agency, and that we have a small working group, and I was chairing that. So I was familiar with many of the issues that were concerning to other regional directors and officials within the agency, career folks within the agency. That it not aligning with the mission of the agency. So having that awareness soon after I started acting, we have incredibly smart, visionary people who are careers within the agency who are also thinking about these issues too. So I was able to quickly receive counsel and look at these issues that have been developing the last 3 years. And what became clear to me was, the criticism I think often laid on the NLRB is the whole oscillation between the parties, and we heard it too with DOL. And what seemed to me pretty clear was, in many of the initiatives that the former General Counsel Rob had put together, those were actually opportunities to change, or wanting to change the existing board law, to flip-flop, to change. And I thought, here's an opportunity to stop that flip-flopping, to keep with the extant law. And what of those initiatives that former General Counsel Rob put together were inconsistent with the extant law? And that was a big part of why a number of those initiatives and memos were rescinded. So that was one significant part. The other significant, and that dealing with neutrality agreements to inflatables, duty of fair representation types of cases, those are all initiatives that the former General Counsel wanted to change in the law. So that was one aspect. The second aspect I thought that was significant was, simply what the mission of the Act. What is the National Labor Relations Act meant to do? And clearly I've purposely done this in the couple of memos that issued, refer back to Section 1 of the Act, encouraging collective bargaining, mutual aid and protection. I mean, that is the mission of the Act. So any of the other initiatives that I thought, and I admit it's subjective, I thought were inconsistent with the mission, I thought those should no longer apply. One significant portion of it, I thought, I think we're going to talk about this a little bit later, so I'll just say, on the agency's obligations to outreach, to talk to the community, let them know what the Act is all about and protections under the Act. And that was one of the guidances that was put by the former General Counsel that I thought was inconsistent with what our mission of the agency should be. So that was, in a summary form, that was what my aim was. It was not the National Labor Relations Board per Peter Orr, what I want. I thought what the agency mission is based on top of keeping, as much as possible, the flip-flopping from starting.
Okay. Well, among those, the memos that you rolled back, the memo on Uber and UberX was not one of those that was rescinded. Is that correct?
Well, I think that was an advice memo, right?
Okay.
So the memos that were rescinding were General Counsel memos, primarily, and operation memos.
Okay.
So for, again, I think there's extent law, and to the extent that I maintain the extent law, I was acting, and UberX, applied, and this was one of the cases from Chicago too, so I'm very familiar with the case.
And just for the audience, that UberX memo essentially stated that based on the particular facts in the advice memo, that UberX was an independent contractor.
That's right.
The drivers were independent contractors and not employees.
And if you read it carefully, I mean, it's certainly based on the board's decision of Super Shuttle, right, which did away with FedEx.
Yes.
And so when you read the advice memo carefully, the whole prism of entrepreneurial opportunity is discussed throughout all the different 10 factors that is looked upon in the analysis between independent contractor and employees. I personally believe that whole entrepreneurial opportunity prism for all the different factors is a wrong way of looking at that test of whether independent contractor versus employees. But it is, the Super Shuttle is the law right now, and I want to be.
Okay, as you said, Super Shuttle overruled FedEx regarding the independent contractor definition. Do you see the General Counsel's office seeking to have the board take another look at that criteria?
I certainly think there's going to be a good hard look on that. I think part of that, and I think it's also similar to our other discussion, and you folks are having discussion, I was going to join in about joint employer matters. The practicalities of how things are, I think, are going to perhaps indicate something that may perhaps the inability for the decisions to actually apply in the real world. How the Super Shuttle decision and the application of it, I think, will show how that in the practice it may not be all that applicable. And as we see more of those cases, I think there's going to be a real opportunity to see whether there's, because FedEx and Super Shuttle, if you look at it at a glance, they don't look that different, right? You have the entrepreneurial opportunity at the end after the 10th one in FedEx versus overall in Super Shuttle, and but it has significant, with the actual application of it, has significant impact on where you come down on the analysis, given especially when you look at who has the burden to establish the individual as an employee, is an independent contractor. That overall prism, I think, makes the practicalities of that burden perhaps not workable. And I think when the facts and the cases come down, that there will be an opportunity to revisit that issue.
Okay. Well, I want to talk about this memorandum GC 2103, which is in the materials. It has a very robust commentary and certainly a very robust title: Effectuation of the National Labor Relations Act through vigorous enforcement of the mutual aid or protection and inherently concerted doctrine. Could you speak about the purpose of issuing this memo?
Again, it was not to state that we were going to look to overturn any current board law, but it was to make sure that the staff in the agency, in looking at these cases, are not so narrowly focused, and also an opportunity for the public to know that we're not so narrowly focused on these board decisions that have issued in such a way that people are missing the forest for the tree. That because it doesn't have this particular item that's not checked off, then we don't have, there may not be a violation. But there has to be a broader approach in the investigation. And some of it is described in the general counsel memo, especially as to the Allstate decision, the Quicken decision, right? It points to those decisions, but it also points to how even in the majority decision, it talks about different facts weighed marshaled differently could have influenced the ultimate decision, and not have everyone start looking at these type of cases and say, oh, it's an Allstate case, there's no longer protected under Act. You folks spent a great deal of time talking about tips. That is the Allstate case. I mean, that is what is not more essential to the terms and conditions of employment for a tip employee. It's the tips, right? I mean, they're not making a living based on the wages. It's on the tips. So I think looking at these decisions and other decisions that have come out from the current board, and not just falling in lockstep as to this decision means there's no protection. This decision, because of these facts, means there's no protection. Rather, look at all these types of cases. What are some of the facts that could have been looked at, investigated differently? And if the facts don't show it, the facts don't show it. But let's make sure that we understand exactly what the facts show to make that determination of whether even within the current board law there could be a violation. And that was primarily to, again, to emphasize to the public, but also our agents in the field, don't just give it a back of the hand kind of treatment. Let's take a careful look at these.
Okay, so if somebody comes with a charge and the scenario looks kind of similar to the facts of Quicken Loan or the facts of Allstate Maintenance, it's not necessarily going to be, those precedents are not necessarily going to disqualify consideration of those facts because there may be other factors in play.
That's right.
Okay. And any comment, Judy, on that?
No, I think Peter's covered that very thoroughly.
All right. How about you, Larry?
No, it's not really. I think the only question I would ask rather is there were administrative policies issued by Rob, and then there were what I'll call adjudicatory issues or issues of substance. They go to the board. So what the general counsel says, not as an advice memo, but a general counsel's memo, is interesting but not determinative, as I understand it. So on the administrative memorandum, changing those, sure, it's within the prerogative of your general counsel, whether there's another word before general counsel as enacted, that doesn't matter. On the adjudicative issues, it just seems to me you have a whole lot of opinions coming out. There is a board. These cases will get to the board, and they would be determined then. I guess we'll forever be debating whether we can have a big blown up rat or not in front of a workplace or not. But seriously, I that's the only point I would make. Is there not a difference between the administrative determinations or rulings or opinions of the general counsel and what I'll call the adjudicative, which are not coming from advice, are coming from the general counsel? And should they not go to the board rather than, regardless of who's issuing them, be just changed by the general counsel? It's just an observation. It's not really certainly not a criticism. It's just a point to make.
Mm-hmm. Okay. MV Transportation. Now, MV Transportation kind of changed the standard with respect to unilateral changes. And there was a standard that pre-existed the issuance of that case that indicated that if it's not in the contract and the employer wants to make a unilateral change, then it cannot do it unless there is clear and unmistakable waiver on the part of the union before it can be done. That was changed to a new standard called the contract coverage standard for determining whether unionized employers' unilateral change is permitted. Recently, NLRB Chair Lauren McFerrin stated in an ABA conference that MV transportation clashes with the NLRA's stated aim of facilitating smooth labor relations by promoting collective bargaining, and that collective bargaining over changes that have not been waived is at the core of the bargaining obligation. Now, as acting general counsel, will you seek to have the board re-examine that contract coverage standard?
Well, this is where it becomes a little bit delicate, right? Because I certainly have my viewpoints on MV transportation, but I also am mindful that the permanent general counsel should have an opportunity to weigh on something as significant as this.
Mm-hmm.
But at a certain point, when the issues do present themselves and decisions have to be made, decisions will have to be made. I mean, I'm not going to be a potted plant, right? But so, I mean, I would say, practically speaking, the contract coverage versus the clear and unmistakable waiver, we haven't seen us in the last couple of years. We haven't seen a significant number of cases that deal with type of unilateral changes issues. But I think that may be part of it because of the pandemic. I think we will start seeing many of these types of cases coming to the board. Obviously initially to the field office, and how that actually plays out. Because the idea of especially when it comes to negotiation on successor contracts and what that means practically, what the negotiation means, I think that's going to have a significant impact, and on what that means with regards to bad faith bargaining, then perhaps based on the unilateral changes. I think it does not assist in a collaborative labor management relationships through the use of contract coverage. The bargaining, as difficult as it is going to be that much more difficult. But we'll have to wait and see what type of cases and allegations we start seeing more and more of as the economy develops. So.
Okay. Well, I want to talk about the student exclusion from the Act withdrawal, but before I do that, I have a public service announcement. For those of you who are looking for CLE credit, the code for today's program is SS3312. SS3312. Okay. Now, the NLRB had the proposed rule, which appeared to be intended to overrule Columbia and reinstate Brown University on a more permanent basis with regard to students as employees and whether or not they'd be covered by the National Labor Relations Act. The rule would have designated students who perform services at a private college or university related to their studies to be primarily students and not employees within the meaning of Section 2.3 of the National Labor Relations Act. The rule was anticipated to go into effect in September. It was withdrawn in March, citing a desire to focus its limited resources on competing labor agency priorities, including the adjudication of unfair labor practice and representation cases currently in process. That sounds like when somebody says, I'm gonna resign because I want to spend more time with my family. It sounds like there's something between the lines that we're not getting. Speculation is that following the expiration of the terms of member Emanuel in August, that there would be a Democratic majority and there would be a move afoot to try to reverse that rule after all of the resources have gone into making the rule. And that maybe that might not be the best expenditure of energies. Judy and Larry, do you guys have any thoughts about that? Judy?
So, I mean, as Marcus, you said from the beginning, I come from Division III land, right? And so what I know of, you know, college athletics in particular is slight. What I know of being a grad student and an adjunct is a bit more. And I will say that I do think that the how do I say this tactfully? The ways that colleges and universities find to make money on the backs of students, on grad students, on adjuncts are many and varied. And I think that is one place where the workforce really has changed over years, especially since the NLRA was written. So I'm glad that the board and the general counsel's office are tackling these issues. And I hope it does so with an eye towards the vulnerabilities of students that are in these institutions.
Okay, Larry, and maybe in a minute, because we're getting
Sure.
close.
Let me just make one point about the MV transportation situation. There is an issue, is a pandemic issue. For example, yesterday, OSHA said that employers could or should follow the CDC rules on masks. Does that mean that if there's a unionized setting, you have to bargain over that and take that longer time? There are all these pandemic rules, which employers were told to put into effect. Practically none of them are covered by a collective bargaining agreement. Just a point to raise. With respect to the college and university situation, it's not only athletes, so Peter determined that in his Northwestern decision. It's really that adjunct teachers, the graduate teachers. And, you know, the board went from Brown to Columbia and back and forth. And I know I sound like a broken record, but consistency would be helpful. We have a whole bunch of colleges, Mark, you pointed out, that have agreed to engage in collective bargaining, and a whole bunch of colleges that have not agreed to engage in collective bargaining. So it's a difficult situation. And just finally, there is an issue. I testified at a congressional hearing, Mark, about your board's activities about employee manuals and things like that. Was the NLRB moving into the reign that Trish's agency perhaps has or other agencies have? And it's just a difficult situation when you have overlapping employment and labor agencies dealing with these issues. And it seems to me, I don't know how it could be done, perhaps agencies should recognize the expertise of their fellow agencies rather than just come up with different rules. I know finally way back when the FTC came out with a rule on investigation of harassment. And that proved to be extremely difficult for employers who wanted to investigate harassment. And the FTC said you have to notify the accused before you investigate. And that's, I think Peter might say, that's not a great way to investigate things, at least initially. So there is this issue. It's not a ideological issue. You have all these agencies overlapping. Peter talked about independent contractor and joint employer. Trish talked about independent contractor and joint employer. Different agencies, different buildings, different leadership, and it's an issue that really should be addressed, as Judy said. There's no answer other than it seems to me it simply should be addressed.
Yeah, just real quickly, Mark, if I may. I think Larry's point is a good point. I think that goes to other points that are made about how difficult the legal structure is on labor employment law and figuring out what law protects whom when. I do think, though, there are different reasons, legitimate reasons why there are different definitions of independent contractors, joint employers, employees in the different agencies based on the laws that they are protecting. But so there may be some good reasons why there is some distinctions. One last plug I will make, though, just not entirely addressing Larry's point, is that there is an attempt with DOL, EEOC, NLRB, different agencies to group all of this information in a single source. And there's one for workers and employees called worker.gov. It's a web page that has resources for all. And then there's another resource, employer.gov, similarly information on behalf of employers. And that is kind of hopefully an attempt to address some of the issues I think, Larry, you're legitimately bringing up.
Okay, well, you shrinking violets, I had to pull teeth to get you to start talking. We ran out of time and we had so much stuff that we could talk about. You all have been so fantastic, and you're such a font of information that we could have went another 90 minutes. But I regret that we have to shut this down just so that everybody can get back to work. I really appreciate the time that you have spent in cogently and fantastically responding to these questions that I blubbered through. Larry and Judy, you've been phenomenal reactions to the information that had been provided by Peter and Tricia. Peter and Tricia, I'm extremely grateful. And I think the college has enjoyed this immensely. So thank you again, and thank everybody for tuning in. It has been a wonderful session, and I hope you enjoy. Be well and be safe.
Thanks, Mark.
Thanks.
Nice working with everyone.